So we're getting started with chapter 20. We just completed chapter 5, then we skipped to chapter 20 right away because there's a lot of terminology in the chapters in between that from chapter 20 that's discussed in them, or words that are used anyway. Some of these things we've already gone over and discussed a bit. So with no further ado, in this chapter, we're going to talk about the 4 methods of title transfer. And what is title?
Ownership.
It's a word that means ownership. There's no document in real estate called title. Correct. So we're going to explain the process of the transfer of title of a deceased person, as well as how it occurs while they're alive. So title to real estate means ownership of the land. So title to real estate is ownership of the land. Alienation is a transfer of title to a parcel of real estate. And alienation can occur while someone's alive during their lifetime or upon their death. After their death, they could dictate who would get their property. Alienation could also be voluntary, that's something you wanted, or it can be involuntary, something you did not. So nothing complicated here, right? Nothing too complicated. You could transfer your property while you're alive or after you die. That's called voluntary. That's called alienation while you're alive or alienation after death. And then you could dictate who you want to get your property when you're alive or after you die through voluntary alienation. Or if that property is taken away from you, or if you die without a will, you don't voluntarily get to say who gets your stuff. So that is a form of involuntary alienation. So is foreclosure, things like this that where your property's taken away against your will. That's involuntary, something you didn't want. So alienation at death could be voluntarily through a will or involuntarily if no will was left, because the state will get your property through the process of escheat if no heirs can be located. So heirs would be your natural blood relatives who would get your stuff upon your death in the event you died without a will. Now, if you were adopted or your parents die, do you get the stuff if they didn't have a will dictating that you get it? We'll get into that. That's a little bit more of a conversation. Kind of, sort of, but not really is the answer. Kind of, sort of. Now, title to real estate means the right to or ownership of the land, and alienation is the transfer of title to that parcel of real estate, which we should highlight, I guess, right? So that's on page 371, which is the same as the 16th edition book, actually. So I don't know what exactly changed that they put in a new edition in this book. We haven't really came across any major changes yet. Some minor stuff. So turn the page. And voluntary alienation can be by gift, sale, or exchange. Owners use some form of deed to convey that ownership during the lifetime or by will to transfer voluntarily upon their death. And transfer of ownership to or from the government. Dedication is when you give land to the government for greater public good, such as streets, schools, and parks. And when you get land from the government, they're granting that ownership to you. So they're granting public property to you. So it's called public grants when the government gives you property. So let's highlight these things. That just go over what we just said. The partition proceeding is in the second paragraph. This part down here, this is the second paragraph on page 373, in case you could not locate it. I'll write that in here too. And let me know when everybody's got those highlights.
Got it.
All righty. So involuntary alienation is transfer without the owner's consent. And this can be done through the process of what we call escheat. It can be done by eminent domain. That's when the government takes land when it's needed for greater public good with just compensation to the owner. Unpaid debts, you don't pay your taxes, your mortgage loan, you could get foreclosed on. By court action through a partition proceeding, when you got a squatter that's on your partition proceeding, when you co-own the property with somebody and they don't want to sell, but you do. They don't want to buy you out or can't. Your options are not to be stuck owning the property with them. You could sue your co-owner, force them to sell or divide the property by partitioning it. So a partition is a court action to physically divide the property if possible. And if they can't physically divide the property, then the judge will order the property sold, and each party will get their proportionate shares of their ownership from those proceeds. Then we have adverse possession through an easement by prescription. This is kind of like squatters' rights, where somebody's been using your property for a long enough period of time as defined by law, whatever that definition is of length of time, then you can take that owner to court and sue them to gain ownership of that property that you've been using. We're going to go over in chapter 7 now, I believe, what's required in order to get an easement by prescription, but we're going to touch on it in this chapter as well. So we're going to start going over a little bit in this chapter. And then erosion. Erosion, that's the wearing away of land by wind or water. And so basically that's Mother Nature's involuntarily taking away your land, right? So that's another example of involuntary alienation. So let's see, in a partition proceeding, okay, we already got this. That was from, let me see, that previous slide. Let me go and steal that notation so that we know. And I'll just write that down here again. There we go. All right. Easement by prescription. This is discussed on several places in the book, page 110, 111, and 373. Let me just confirm 110, 111 before you go writing it down. Just want to confirm all my notes are correct in this latest version of the book. 110, easement by prescription. Yep, that's still correct. So, easement by prescription, sometimes known as squatters' rights, okay? This is through adverse possession. When somebody's been adversely possessing your property and using it for a period of time as defined by law, but not with your permission to. It's against your permission. It's hostile. It's adverse to the owner's title. So when you've used someone else's property for a period of time as defined by law, an easement by prescription may be claimed. However, to perfect that claim of easement by prescription, it requires a court action called a suit for adverse possession. It's basically to claim the ownership of the land. The way to perfect this easement is you need to take the owner to court. Just because you've been using their property for a period of time as defined by law does not make you the owner. You have to take them to court and claim that ownership and prove it. Now, the use must be, in order to perfect that claim, the use must have been continuous, hostile, adverse to the owner's title, exclusive, and without the owner's approval, even though any of these terms are actually not stated in the specific statutes according to law. But those are the requirements in order to successfully claim an easement by prescription. Additionally, that use had to have been visible, open, and notorious. So basically, it's obvious to the public that you've been using the property. It's not like you've been sneaking on the property for years and you've been there for years and nobody's seen you, or you got an underground doggy fence that's hidden on the property, an invisible fence that you know about and only you know about. It has to be obvious that you're using the property out in the open against the owner's permission, but yet they didn't take any actions against you to get you physically removed from the property, and you've been doing it for the amount of time that was required under law. Then you could take them to court, claim that ownership. So the prescriptive period in New Jersey to successfully win an adverse possession suit is 30 years for improved lands. Improved lands does not necessarily mean that there's a structure on it. It just means that there's a man-made improvement of some sort. It could be a paved road. Okay, now that property is improved. It has improvements on it. So the prescriptive period is 30 years for improved lands in New Jersey, 60 years for unimproved woodlands. You know, the ones that there's no man-made improvements on the property. Now, at some point in the future, this law is going to change to 20 years. Let's take a look and see if they put any change in the wording here in the book. Does not appear they did, but they may have cleared up a little confusion until the law is actually changed, because we've been expecting this change now for like 12 years already. I've been tracking it for like 11. So our politicians have been wanting to change it. There was a lawsuit where somebody sued someone else trying to claim an easement by prescription on a property to take ownership of the land. And they were unable to do so. The judge kicked it out of court because there was an argument by both sides that shows that there are laws currently on our books in New Jersey that are conflicting with each other. Our politicians in New Jersey, they love making new laws. Sometimes they're very repetitive in their lawmaking on the same topic because they want to impress somebody or say, look, I just proposed a law. It's like they do with the gun laws, right? The gun control laws. You know, somebody gets shot and then they step forward. Oh, I proposed a new gun law, these new stronger gun measures to try to whatever, okay? And they try to play the hero. Well, the same thing happens here. They keep proposing laws and they keep making laws, and there's already laws covering the topic. So it's kind of needless to do. And in this case, though, when they proposed these extra laws, what they ended up doing is they ended up creating a conflict. And if there are multiple laws that cover the same topic, and there's different rules for them, and somebody decides they want to sue, a judge cannot render a decision because the law is not clear. What is a judge's job? Anybody know? What's a judge's job? You know, you go to court. What's a judge's job? Their job is to interpret the law. They don't make the law. A judge's job is to interpret the law that is created by the politicians, like Congress, right, at the national level. Well, New Jersey has its own state legislature that makes laws. And when they make too many laws that conflict with each other, a judge cannot rule on that. They should not rule on that. They should kick it out of court and kick it back to the politicians to clear up their mess. And then the case can be brought forth again. And at that point, the judge can render a decision based on what the established law is. A judge's job is not to legislate from the bench. That means, you guys may have heard that saying before, legislating from the bench. That's when a judge makes a haste response. And what they do is they create de facto law by creating a precedent in making a ruling on a court case where the law was not spelled out or something was not mentioned in the law. Instead of kicking it to the politicians to create a law about it, or for politicians to clear up the laws, a judge could render a decision, but by doing so, they kind of create a precedent that then is followed. It's customary that precedent is followed in the law. But they did not just create a law. Some people say it's kind of sort of like creating the law because it's a precedent. Now all other rulings that judges make, they're not going to conflict with that ruling. But it's not a law because the politicians make the law, not judges, and no politicians ever ruled on it. A perfect example of this was a year or two ago. You guys remember the whole abortion thing, the whole abortion rule? People were all outraged. Oh, protests, you know, people are going to die because we don't have abortion. Stupid statements anyway. But people were all outraged over this kind of nonsense. And they're like, this is established law. You're getting politicians that get up on their bully pulpits and they start screaming in the media because they just want to get on the news. I'm going to protect health care, your right to abortion. That's health care now. So I'm going to protect it. We're going to what? Pass a law? No. Instead, they just argue against the president or against the Supreme Court, who rendered a ruling because somebody sued the government, because the government never created a law about abortion. Instead, what happened was 50 years ago, they say this is 50 years of established law. No, it's not. It's 50 years of precedent where people were honoring a decision that a judge made. But once somebody sues and that lawsuit directly deals with that precedent that the judge made, a question can be brought up of whether there actually is a law on this. Or did the judge make an improper decision from the bench that everybody's been following for years? And that's exactly what happened. And it went up to the Supreme Court, and the Supreme Court said, we don't see any law in the book about abortion. So because there's no laws on the books, we're going to cancel that judge's precedent decision. There's no law. So what we're going to do is we're not going to pass a law at the Supreme Court because that's not our job. It's the legislature's job. So we're just going to kick it out, and we're going to let each state make their own laws on the topic and make their own decisions, unless the Congress and the Senate of the United States of America decides to create a law, which they don't. They just give a lot of lip service all the time about, oh, they're going to protect you, but then they don't do nothing. Well, at the state level, the same stuff happens. This is my point that I'm making. It's not to give a rant about abortion and abortion law. It's just showing something recent that was in the news Where you get politicians that they give you lip service, but they really don't do nothing. They didn't pass any laws. A judge cannot make a decision based on it. And when they do, it could always be overturned because there was no law on the topic to begin with. So this is over here, what happens in New Jersey is that the politicians made too many laws and then they conflicted with each other. And then a judge kicked it out of court. He can't make a decision when the politicians make multiple laws that are conflicting with each other, because it would be the same kind of deal where they would be creating precedents and establishing a law. And the judge rightfully kicked it out and said, I can't do that. That's beyond my scope of my authority. So kicked it back to legislature. And now about 12 years later, we know that New Jersey legislature wants to turn the 30-year and 60-year law. They want to do away with those time limits, and they want to make it a 20-year, just like the common law throughout most states when they don't have an established specific law for the time period. So in New Jersey, the easement by prescription period is eventually going to be changed to 20 years. But as of right now, what you should study for exams, what's the prescriptive period? It is 30 years for improved lands, 60 years for unimproved lands. So the prescriptive period in New Jersey is that it's going to eventually change to 20, but this is what you should study, what's in bold. And through the process of tacking, if one person did not continuously, exclusively use that property for a period of time, you could tack on another person's time of use of that property to yours to reach that prescriptive period. But you would have had to have been some sort of successors of an interest, like an owner and an heir to that owner, a landlord to a tenant, things of this nature. Let's see. So there had to have been some sort of relationship between the parties. So let me see if the book changed up these notes at all, or if they're exactly the same. I don't know. I think these are exactly the same, actually. So we'll see in a second. Highlight exactly what we got here, and I'll let you know. As I highlight through it, we'll find out if the notes have changed at all, but I don't think they have. So adverse possession in New Jersey, yep, that's the same. That first highlight's the same. And then the next one, second paragraph, tacking continuous periods of adverse use can be combined by successive users. Okay, that is the same. Then let's also underline the word tacking, because tacking is a word we need to understand as well. And then the process is not automatic. Legal action is necessary to perfect the claim. That is true. You do not automatically get ownership of someone else's property because you've been using it. You have to perfect that claim. Now, let's see. Adverse possession is not possible against publicly owned property. This is true, although I'm not going to have you highlight it, even though you may get a question on that. Let's see, what do we call that claim? It's a suit for adverse possession to quiet title. So adverse possession, you know, we could actually put this up top too. Adverse possession / easement by prescription. Yeah, where it says involuntary transfer, that's involuntary is another word, involuntary alienation, right? Involuntary transfer. Now, alienation is another word for transfer, so write that above that. Alienation. So adverse possession / easement by prescription. And then we could write there page 110 and 111, chapter 7, I believe that is. And then underneath here, make sure you write that call the suit for adverse possession or suit to quiet title. You know what? Right down here, you should highlight this too. To prevent such loss of title, every person having the right to title to real estate must inspect their property at least once every 30 years and take action against any adverse claim. You want to prevent somebody from taking your property, remove them from your property if they're using it, all right? And the rest of that paragraph, I'm just going to put a bracket around it with my pen because it's interesting, useful information, but not on exam. This is an interesting topic here. Property owners who feel that new government regulations have been put into place. So, for example, when the local government creates all these zoning laws, rules, and regulations that dictate how you could use your property, when the local government or the federal government or the combination of both of them, they create so many laws, rules, and regulations about how you could use your property or limit how you can, to the point that it renders your property useless, that you can't do nothing with it. Didn't they just basically devalue your property? If the government put rules in place how you could use your property, and it basically says that, well, your property, you can't do nothing with it now, didn't they just make it worthless? And if they made it worthless, you could sue the government now, because they basically created all these rules and regulations restricting you on your own use of your property, that they basically rendered your property worthless, and they devalued it. So you could sue them for the compensation of that loss of value. All right, let me know when you guys are done with all the highlights and notes and all that jazz.
Got it.
Got it. Got it.
All right. I'm just going to do some digital highlights here. Drop that on this. All right. So, all right. So an easement by prescription. This is back. Oh, actually, it was in chapter 6, not in chapter 7. Make that correction here in my book. We're chapter 7. And we got whiteout tape. All right, so later on, we're not going to go back to chapter 6 right now to do these highlights. We'll do them when we get to chapter 6, which will be right after we do this chapter 20 here. So an easement by prescription is when someone's used another person's land for a certain period of time as defined by state law. An easement by prescription may be claimed. That claimant's use must be visible, open. Okay, now this is all the information that I have on this slide. So let's just stick to this slide that I made. So where we went over all of that stuff. And then I also put here how you could prevent somebody from claiming an easement by prescription. An owner can take legal action against any adverse possessor. So walk your property at least once every 30 years and then take action to remove them. Cut off their access. So if you stop their continuous use, their continuous access, that's one of the requirements. Their use must have been continuous, open, let's see, adverse title, exclusive without the owner's continuous, hostile, adverse to the owner's title, exclusive, and without the owner's approval. So if you cut off their access, you reset the time clock of that 30 years. Or you could simply give them permission to be on your land. They can't claim an easement by prescription to claim ownership of the land if you gave them permission to use it. It has to be against the owner's permission. So continuous, hostile, adverse to the owner's title, exclusive, and without the owner's approval. All right. So the claim, you can't claim an easement without with the owner's permission to use the land. And a little note here, an easement by prescription cannot be claimed against publicly owned land. Okay. You can't claim an easement by prescription because you decide that you're going to put up a tent and live in a campsite in a park. Okay. Otherwise, we'd have tons of homeless people claiming the parks to own the parks. You guys take a picture of this slide? You may want to. Can I change it? Or is anybody going to take a picture?
Got it.
The picture.
All right. So the transfer of a deceased person's property, once again, title is just a word that means ownership. There's no document in real estate called a title. Deed is the document that's used to transfer that title, one's rights, title, or interest in a property. If they have a partial ownership interest, if they have air rights, subsurface rights, mineral rights, there's going to be some sort of deed of conveyance to transfer that ownership or rights that person has. Okay, so a deed is the document used to transfer that ownership. And a will, the last will and testament, that is a document that dictates how to dispose of your assets, how you wish to dispose of your assets, who you want to get your stuff basically when you die. So a will would be, if you have a will, it would be a voluntary alienation after death. So transfer of title by will is known as devise. not demise, because demise is a transfer of property by lease. So devise is a transfer of property by will upon death. Testate means that you prepared a will and how you wish to devise that property to someone. Or that's using a lot of fancy new words right now that we're just learning. In basic plain English, testate means that you prepared a will stating how to dispose of your assets after you die. A will has no power until after you die. Because how do you transfer property while you're alive? Can you still sell your property while you're alive? If you made a will and you named somebody to get that property after you die, can you still sell it while you're alive?
I think so.
Sure you can. Do you own a car?
Yes.
Now, anybody here have a will in this class?
No. No, I don't.
Okay, if you had a will that you named, I don't know, a relative or your best friend to get your car if you die, can you still sell your car while you're alive?
Of course.
Same situation with the house, with
Mm.
real estate. Even though you name somebody of who you want to get your stuff, if you don't update your will and you already sold the stuff, you don't got that stuff no more, well, then they don't get it because you don't got it to give. It's simple as that, right? So this is why periodically you should update your wills. Now, anybody here have kids?
No.
No.
Oh, okay. Well, either way, you know, even if you're young and you don't have kids or family or anything yet, you still got assets. You should dictate who you want to get your stuff, because if you don't, then it has to go through probate. The judge has to assign somebody to manage your estate, verify who the valid heirs are, which would only be your blood relatives, and then they could get your stuff. But it's a process. It's long, it's drawn out. It would be a lot smoother, quicker process if you did have a will, and the court would not have to appoint somebody that they're paying 10% to give of your estate to determine who that is and then give it to them. Okay. Do you want the state to get your stuff when you die? Or do you want your friends and family to get it? Or charity even? You know, so if you do not have a will, this is what could happen. The state could end up getting your stuff if nobody steps forward, because they're not actively out there searching to see who you're trying to find your relatives. They posted on a website that you died and this was your stuff, and they got 1 year to claim it. If they don't, then the state keeps it. So remember the missingmoney.com, the one that New Jersey used to be in, and now they have that unclaimed property.nj.us. But by the way, did anybody look up in there and see if they got anything coming their way? Remember those links I showed you?
Yeah, I didn't have anything.
Same.
No relatives, no nobody?
No.
Your parents, your aunts, uncles, cousins, you look up their names and nothing? Look them up, look them up. I bet you'll find somebody, guys. Somebody's always got money coming to them, and it ends up going to the state. So testate means you prepared a will, deciding how you want to dispose of those assets when you die. So the transfer of title by descent takes effect only when you die. Intestate, and it's involuntary because you didn't have the will dictating who to get it. So every state has their own laws of descent and distribution that dictates who gets your stuff if you die without a will. You should consult an attorney about making a will and what your options are. Everybody should have a will, But you guys, listen, you could go get like Quicken Will Maker or something for like $15. It's or Susie Orman Will Maker, Quicken Will Maker. It's like $15 and it's legal in all 50 states. You could follow the directions, type in what the answers are. It'll print out a will for you. But those kinds of wills require 2 witnesses' signatures that should be notarized. And somebody who is a beneficiary of a will can also serve as a witness, okay, to it. But make sure if you have a will, people could find it, somebody you trust. Make sure you got copies of it laying around where people can get a hang of it, okay? A will serves you no good if nobody can find it. Make sure it's dated so that if you ever update it and make a new will, the latest will takes precedence. So transfer of a deceased person's property, intestate. That means you died without a will. Testate, you died with one. So let's highlight those on the bottom of page 373. Testate or intestate, involuntary, without having left the will. And testate means that you have prepared a will. And then under probate proceedings, highlight that first sentence that dictates, that says what probate is. Probate is a court proceeding that when somebody dies, it determines what the assets of that estate are and verifies who the natural heirs are if you died without a will, or if you died with a will, it verifies the will and it's legitimate and who the people are that are going to get distributed your assets. Now, an executor or an executrix, that's a female, executor's a male, would be somebody that you name in your will that you make, that you trust, that's a person who you want to make sure and put in charge of your will of distributing your assets according to your wishes. So that should be a trustworthy person, close friend or family member, what have you, who you want to read your will and make sure that your assets are distributed according to your final wishes. If you did not name an executor or an executrix in your will, the state will appoint an administrator. An administrator is somebody named by a court to do that job. All right, and that's usually an attorney. But sometimes it could be a relative if it's obvious that somebody is a close relative, that the court could appoint them as well. Now here's a bunch of death terms. Now, in an earlier chapter we had this, and I believe that I made some updates and additions to this as well. What chapter was that we were going over these death terms? It was chapter 5, wasn't it? Let me go to chapter 5 really quick. Open up that slideshow and steal that slideshow because I know I added some terms in there. So I'm going to update this slide here in chapter 20 as well with those terminology that had been updated. So yeah, I'll give you 1 second with that. All right, I got it open and I got those death terms. And so chapter 20 and or maybe I already did that. I think I already did that. And it's got a spelling mistake in there, so we should probably fix that. Save that. Copy that. Go to chapter 20 and replace that. Delete that. And now we're good. We've got chapter 5 slideshow. And remember to update it later. And let's go back to chapter 20 slideshow. Here we go. And you guys can still see chapter 20 slideshow. That never left your screen, right?
We can see it.
Okay. So an heir is a natural blood relative who can inherit belongings of a relative who died. A devise is a transfer of property by will upon death. Devisor is the person who's leaving you that property. The devisee is the one who's receiving those belongings, that property. Demise is not to be confused with devise. A transfer of property by lease is demise, the one that sounds like death, but is not. Testate means you prepared a will. Intestate means you did not. Testator is a male. Testatrix is a female who made a will. Probate is a court proceeding to determine who the natural heirs are, or to inform or to confirm who the devisees of an estate are, no matter if you had a will or not, and what the assets are after all debts have been paid, mainly your taxes, because two things are certain in life: death and taxes. We're all going to die, and we all got to pay taxes, even after we die. An executor is a male, and an executrix is a female who you would have named in a will to be in charge of distributing your assets according to your final wishes in your will. An administrator, somebody who is appointed by the court to do that if you did not appoint somebody to do it. Descent and distribution, probably be better and save more space if I just wrote it that way, right? Executor is a male, executrix is a female. These are persons named in a will to ensure your wishes are carried out as outlined in the last will and testament. Let's make that even easier to understand. Executrix are trusted, or is a trusted person you name in a will to ensure your final wishes are carried out as outlined in the will, in your last will and testament, on how to distribute your assets. If you did not name an executor or executrix, the court will appoint an administrator to take on those duties. Instead of repeating the whole thing with just somebody else's name there, boom, boom, boom. And that is that. And that is all. And I guess I'll go to chapter 5 and update that one again. But in the meantime, I'll do that in the background. So I guess that had popped up really quick. Descent and distribution is the law that determines who gets your assets, at least your natural heirs who get your assets if you die intestate. So it determines who your natural heirs are to get your assets if you die intestate. That sucks. The law that determines who your natural heirs are to get your assets if you die intestate. All right, whatever. Look at that. And escheat is when you die intestate and no heirs can be located. The property reverts to the state. Property sold at auction and the money's held in a fund for 1 year in which heirs can claim it. If nobody steps forward to claim it, the state will get the money or assets. See chapter 9, page 145, and chapter 20, page 374, 375. Okay. Legacy bequests. A legacy is your personal property that you've amassed during your lifetime. The bequest is your wishes of who you wish to get it. I bequeath to thee my vast fortune of $4 in my bank account, right? So that's your bequests to leave your legacy to someone. And dower and courtesy are ancient New Jersey rights, New Jersey specific here. Dower and courtesy are rights where a spouse has interest in their significant other's property that they owned before they died. So the dower is the ancient right in which the wife has certain interest upon her husband's death in any real estate he owned during their marriage. And courtesy is a similar right the husband has in any property that the wife owned during their marriage. New Jersey abolished the creation of any new dower or courtesy rights as of May 28, 1980. That means any existing ones that are out there are still in effect, but after May 28, 1980, they were no longer creating dower and courtesy rights. So marriages after this date, the spouse only has the right of interest in the primary marital residence, and of course, anything you left them in your will or in the will. So, how do you remember dower? Because you need to know, first of all, you need to know what dower and courtesy is. You need to memorize that date. When did New Jersey abolish the creation of any new dower or courtesy rights? May 28th, 1980. Which one is the wife's right and which one is the husband's right? Dower is the wife's right in the husband's estate. Courtesy is the husband's right in the wife's estate upon her death. So an easy way to remember this is this. Dower begins with a doe. And a doe is a deer, a female deer. Let's remember it with a little song. And courtesy is because men are courteous to women. That's the way I remember that. That's the man's right, the husband's right. And let's not even get into gay marriage because gay marriage was not a thing in May 28, 1980. Back then. There was no gay marriage. That wasn't signed into law until Governor Christie just a few years back. One of his last acts as the governor, he signed gay marriage into law in New Jersey. So dower and courtesy rights. Dower is the wife's right because the doe is a deer, a female deer. So that's the wife's right. And courtesy because men are courteous to women, or they should be. So courtesy is the husband's right. That's the way I remember them. Hopefully that helps you as well. Silly little ways like this to remember stuff. It does work. All right, moving along. Transfer of title by will. So a last will and testament is a document or fancy word for a document is instrument, made by an owner to voluntarily convey title to the owner's property upon their death. A will takes effect only after that person dies. Up until then, they're free to sell whatever property they own while they're alive. A party who makes a will is known as a testator, because testate means you died with a will, right? So a testator is the one who made the will. Or if you're a female, you're a testatrix. The gift of real property is known as devise. Okay, so let's do those highlights. I'll do them right along with you. This is on page 374. The first sentence under transfer of title by will. Then the testator devise. A party who makes a will is known as a testator or testatrix. And the gift of real property by will is known as devise. Not demise, because demise is a transfer of property by lease. And anybody who gets that property by will is known as a devisee. The devisor is the one who's giving you that property. The devisee is the one who's receiving it. Remember, words that end in OR is the person who's giving whatever the root word is. Words that end in EE is the one who is receiving it. I wrote that here on the side of this page here, too. So you may want to make that little note right here on the side. See page 120, remembering legal terms. And then OR in quotes versus EE. So basically, when remembering these words, like devise is to leave property by will. So as long as we know that root word and what it means, if we were to put an OR at the end of it, devisor, that's the one who's leaving you that property in a will. And a devisee, ending in EE, is the one that's receiving it. Any word that ends in OR is the person that's giving whatever the root word is. Any word ending in EE is the one who's receiving whatever that root word is. Same thing with a lease, right? Who gives the lease? The lessor. That's the landlord. And the lessee is the one who receives the lease. That's the tenant. It makes it a lot simpler to understand these terms, doesn't it? And then we have under here, the next paragraph, right of election. A right of election is reserved for a surviving spouse, but let's just, I don't even know if you need to highlight that, but I am. Right of election. So what is a right of election? You're probably not going to get that on exam, but I'm going to explain this anyway. The right of election is basically, let's read the whole paragraph to give you a fuller understanding of it. In New Jersey, children can be disinherited. So be good to your parents. Actually, you shouldn't be good to your parents just because you're hoping they're going to give you stuff, but be good to your parents. But a surviving spouse is entitled to at least 1/3 of the estate. And a determination of the augmented estate is a complex calculation. Now, if your spouse tries to write you out of the will or leave you less than that 1/3, the right of election is what this spouse can claim, that surviving spouse can claim, instead of just accepting being written out of the will or being left the lesser share that the law required that your spouse leave to you. So if you're married and your spouse died, but they had a will, and in that will, they either left you nothing or left you less than 1/3 of the estate, you could say, nah, I'm gonna exercise my right of election instead and take the 1/3 of the estate that they were required to leave me by minimum by law. So you can't write your spouse out of the will. Well, you can write them out of the will, but they could always exercise their right of election and take 1/3 of the estate anyway. That's the law on it. That's how it works. Okay. So, gentlemen, can you write your wife out of the will and instead leave everything to your girlfriend? Joke. Yeah, sure you can. But then your wife can be like, nah, I'm going to exercise my right of election and get 1/3 of it. If you were to do such a thing. So a will differs from a deed in that a deed conveys the present interest in the real estate during the lifetime of the grantor. And while it conveys no interest until after the death of the testator. Okay, so basically, you're basically another way of saying your will takes effect after you die and has no power whatsoever as long as you're still living. You could always change it. You could sell the stuff that's in it. So to be valid, deed must be delivered during the lifetime of the grantor. Yes, if you are to sell a property, your deed must be delivered during the lifetime of the grantor. So let's highlight that. To be valid, a deed must be delivered during the lifetime of the grantor. Because if you didn't deliver it and you die, how does the property transfer?
Involuntary alienation.
And so how does it transfer though? That's correct, but how? How do we transfer property after our death? How do we do it voluntarily after we die? How do you dictate who gets your stuff after you die?
You write them on your will.
In a will. In a will. So if you die and you never delivered that deed, your property ownership gets transferred by a will, or if you hadn't made no will, according to the heirs, whoever the natural heirs are. And if no heirs step forward through the process of escheat, the state gets your stuff. Jervin's, your speaker working or what? I see you sent a text message for the answer for that. You're sending me the will. Is that it? Your speaker's not working, or your microphone? Okay. You just so that you know, if you go to your if you go to your that little arrow button where the mute button is, by the way, if there's a red line through it, just click on it and that unmutes you, or you could hit the space bar, does the same thing. But if that's still not working, there's a little arrow down tick button next to the mute button. And you could select a different microphone or test it out or select the right device and play with the audio settings to try to get it to work, okay? All right, let's see. So this is that chart, OR versus EE, which can be found on page 120. And you don't got to go there now. We'll go there and we'll highlight it when we get to chapter 7. But basically I did this. I wrote OR and EE above person giving the product, person receiving it. You see what the root word is. Words that end in OR is the one that's giving it. Words that end in EE is the one that's receiving it. And we got devise, we got grant, legacy, lease, mortgage, offer, option, sublease, trust options on that as well. So we'll go over that when we get to chapter 7. Legal requirements for making a will. To make a will, by the way, you can make a will right now. You can write something on a napkin and it'll be legally valid. All right, because it's in your handwriting. Okay. But if you had a chance and opportunity to sit down and put it in writing, you know, if you type it up and print it, you need to have 2 witnesses, and those witnesses' signatures should be notarized. If you handwrite the entire will, this is called a holographic will and does not require any signatures, or does not require any witnesses. Sorry about that. So you don't need to highlight this. I just have it highlighted so that I could explain it. Remember to explain that to people. So a holographic will is handwritten will. That's all it is. Requires no witnesses. And everybody should have a will. I know we don't want to think about mortality, but look, a component that could be also added to the will is a living will. You get into an accident, you become paralyzed and you become a vegetable. Do you want to do not resuscitate option, or do you want them to do everything they can to keep you alive? You know, things like this, that's called a living will. So these are components that could be added into a will as well. Who's going to make those decisions on your behalf? Do you want? You know, things like this are what you could put in a will. What do you want done to your body when you die? Do you want to be cremated? Do you want to be buried? Where? You know, these are things that can be spelled out for in the will as well. You know, a lot of people don't think of adding them, but look, you may have paid for a burial plot somewhere already and have it all planned out. But if nobody knows about it, you're going to get buried wherever they put you. Excuse me. All right, so any person who's of sound mind and 18 years of age or older can make a will devising their property. All wills have to be in writing in order to be valid. Video wills, audio wills, they're not valid, not in New Jersey. So the general rule is that a will must be witnessed by 2 persons. A beneficiary could serve as a witness in New Jersey. If the signatures of the witnesses are notarized within 2 days, probate proceedings can be simplified. And a holographic will is a will that's handwritten and requires no witnesses, because the entire thing is in your handwriting. So it's harder to forge an entire document in your handwriting than just your signature, right? So for real property acquired by a married deceased person before May 28, 1980, the surviving spouse is entitled to a life estate of 1/2 interest in all the real estate owned by that deceased, no matter what other provisions were made for in a will. So you get 1/3 of it. If you're married after May 28th, you get 1/2 of all the property if you're married before. But if you're married after May 28th, your spouse only has interest in the primary marital residence. If you have other properties, they do not have any interest in those properties. So, title to real estate and personal property of a person who dies intestate passes on to their heirs. And under the descent statutes, the primary heir of a deceased are their spouse, civil partner or domestic partner, or close blood relative. And when children have been legally adopted, most states consider them to be heirs of the adopting parents, but not heirs of the ancestors of the adopting parents. What does that mean? That means that you can inherit from your parents who have adopted you, but you cannot inherit and claim to be an heir of their brothers and sisters and their parents and such. Even though you may refer to them as your uncles and grandparents, when you're adopted, technically they're not. They're not your blood relatives. So you cannot claim any of their assets unless they specifically named you in a will to leave it to you. All right, now these laws are going to get a little medieval now. They sound like they're really old in nature. In most states, illegitimate children inherit from the mother, but they do not inherit from the father, unless he had admitted parentage in writing or parentage had been established legally in some other manner. Okay, well, what does that mean, illegitimate child? Anybody know what an illegitimate child is? It's when your parents, if you were born and your parents were not married. Now, let me put this in terms that the younger crowd can understand that followed like Game of Thrones on TV. You are the bastard child. Okay, so when your parents were not married, you're considered illegitimate in the eyes of God and under the law, which was old law here. You're an illegitimate child, so you can inherit from the mother because we know that you came from her, but you cannot inherit even from your blood father unless he's admitted parentage or they've proven that he was the father in some way because they weren't married. And if he legally adopts such a child, that child inherits just like an adopted child would. Here, let me throw another little whammy out there for you. Because you cannot inherit from your actual father who made the donation that made you his child, unless he's admitted it, if your parents were not married. Check this out. If your mom got married from if your mom had a child from somebody that was not the husband she was married to, the guy that she was married to, by law, is the father. And he's required to take care of that child. Our politicians should be updating some of these laws instead of trying to create new taxes and figure out new ways to screw the public on how they could blow your money. This is some old laws that are screwed up. Instead, you got politicians out there trying to change laws that make things like incest legal in New Jersey. Sickos. This actually happened in New Jersey a couple of years back. Actually, it's quite a few years already. I forget how many years ago it was. It was always on the books here in New Jersey that you can't have sex with your own kid. That's disgusting. You know, New Jersey politicians, they changed that law, so it's not a crime. Why the hell would you do that? Well, they did. They did. As a matter of fact, if you guys want, you can look it up on 2020. If you remember that program on TV, 2020 or 60 Minutes. It was one of those, 2020 or 60 Minutes. They had a program based on this, where you've seen this young girl who was married to this much older gentleman, or they wanted to get married, and they moved back to New Jersey so that they could do so, because every state that they were in would not allow them to marry, because that was her blood father. Oh, disgusting. And it's disgusting New Jersey would create a law like that would allow such thing. But yet they can't dictate and change the law about what the prescriptive period is for an easement by prescription 12 years later. They're doing laws like this and overturning them like that. And if they want a new gas tax, what did it take them? 30 days? Boom, new tax created. When it comes to getting your money, oh, they're quick. They're on the button there. Or when it comes to creating voting anomalies, you know, other ways to vote, they're all over. unless it's, of course, requiring you to show an ID. You need an ID to get a real estate license, but you don't need one to vote. So intestate real property is distributed according to the laws of the state in which the property is located. Ooh, keep that in mind. New Jersey law of descent and distribution provides that real property belonging to an individual who has died intestate is distributed according to the following order. Okay, so what does that mean, intestate?
No will?
You died without a will. So if you died without a will, and this is only if you died without a will, who gets your stuff? What determines who gets your stuff? Well, the law of descent and distribution. So these are the laws of descent and distribution we're about to go over, okay? So transfer of property by descent and distribution. This is what's on this slide and on page 375. So once again, this only takes effect if you died without a will. Your surviving spouse or partner becomes the sole heir if you did not have any parents or children. Now, if you did have a child or children who are also children of the surviving spouse, the spouse or partner receives the first $50,000 of your estate plus 1/2 of the remaining estate. The rest goes to the child or children. If the descendant leaves parents and a spouse but no children, the spouse or partner receives the first $50,000 plus 1/2 the estate. The rest goes to your parent or parents. If there are children who are not children of the surviving spouse, the spouse or partner receives 1/2 the estate, the child or children the other 1/2. Where no spouse or partner survives, children become sole natural heirs. And where there's neither surviving spouse nor children or their own heirs, the estate first goes to parents, and failing that, to brothers, sisters, or their heirs. In default of any other natural heir, grandparents, aunts, uncles, and first cousins may be considered heirs. Beyond that point, the entire estate goes to the state of New Jersey through the process of escheat. You may want to highlight that right there, escheat. And now the rest of this, I think, talks about how escheat works. So I'm going to put a bracket around the remaining part of this paragraph, which explains escheat. So the state treasurer sells the property at public sale, giving notice by publication in newspaper in Trenton and whatever the major newspaper publication is in the county in which you live. The proceeds of the sale are held in a fund for 1 year. If no claims are made within that year, the state keeps your money for that sold asset. Now, if you want to see if you got property coming your way, once again, New Jersey used to be a part of missingmoney.com, like a lot of other states are, but they pulled out of it and they created their own version of that site. And it is unclaimedproperty.nj.gov. But any federal stuff or things from other states would be in missingmoney.com. So search both those sites. But the New Jersey one is unclaimedproperty.nj.gov. So I'm going to write those links in my book, and then we're going to go on. We're done with this chapter, and we're going to do the key terms to review, and we'll move from there. So. Okay, All right, so let's do the key terms to review. There's only one of them for chapter 20. Let me just make sure nothing changed here and all this stuff is still the same. And it looks like it is. So give me 1 second to run down the answers. Next to letter number 5, where it says executor, write a slash and write executrix. EXECUTRIX, executrix. And next to letter 12, where it says testator, write a slash and write testatrix. TESTATRIX, executrix. Okay, so a person named by the state to administer a descendant's will.
Administrator.
One is A, it's an administrator, correct. That's somebody who's named by the court if you didn't name somebody in a will to dictate who gets your stuff. A court proceeding to establish the validity of a will.
Probate.
10 is B, probate. Title acquired by usage. When you've been using a property for a period of time as defined by law, you can claim ownership of it.
Adverse possession.
2 is C, adverse possession. Person named in a will to administer the descendant's estate.
Executor/executrix.
5 is D, correct. Transfer of title without the grantor's consent.
Involuntary alienation.
8 is E, involuntary alienation, without having made a will.
Intestate.
7 is F. What do you call the person who makes a will?
Testate.
What do you call the person who makes the will? Testate's when you had a will, but what do you call the person? who makes the will?
Testator.
That's the testator or testatrix, correct. 12 is G. Document disposing of person, a document disposing of property after one's death. What do you call that document that dictates how to dispose of your property after you die?
Last will and testament.
Yes. 9 is H, last will and testament. Having made a will.
Testate.
Testate. 11 is I. Acquiring of property by natural heirs. Your blood relatives. Determining who those people are. We just went over reading the process of descendant distribution. So it's descent. 3 is J. One who receives real property through a will.
Devisee.
4 is K. One who can inherit.
Heir.
Heir, an heir. 6 is L. That's somebody who can inherit because they're a blood relative, right? You may want to write that after one who can inherit, right? Blood relative. Now, adopted children can still inherit, but only from the adopting parents, not the extended family. That's the key there that you got to understand, okay? That's why I wrote blood relative, because if you're a blood relative, you could claim to be an heir of the extended family as well, your parents' parents and their brothers and sisters and so on and so forth. Otherwise, if you're adopted, you could only get stuff from those people if they specifically left it to you in a will. A transfer of title with the grantor's consent. Transfer. Oh wait, we already. Wait, did we? Oh yeah, the transfer of property with the grantor's consent.
Voluntary alienation.
Yeah, 13 is M. Okay, there we go. So, okay, yeah, that's it. That's all of them. All right, let's go back. That concludes chapter 20. And you know what? I'm going to end this recording right here, and then we're going to go back. I'm going to start a new recording for the next chapter, chapter 6, so that this way I could at least have them in order according to their chapters in the recording slideshow or the recordings, that recorded list. So let me